up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man, you're going to learn.
Right off the bat, this is a huge red flag. He's openly admitting that he planned to ignore court orders, which in legal terms is essentially handing the prosecution evidence on a silver platter. It really makes you wonder whether he understands just how badly this could backfire against him in court.
Court calls the case of the people versus Marquesi Hankey.
I'm letting them be happy, Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, except one.
All right, it's your motion.
There's probably a motion to take the previous PCC hearing. My client's bond vote from privileges from the jail suspended due to allegations that he put off tether and contacting the complainant. Following that particular volunteering period, I instructed my client to not contact the complainant witness period from the jail. I also instructed my client that if allowed to be back on bond, we would ask the court to hopefully reinstate his original bond with tether. We know judge that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, and again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. Yes.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something it means. So I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he did post to a bondsman. The only thing I can make sure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest restricted issue. So just I'm asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he never have had any contact with his family, his children? He hasn't been able to contact his dad, caretaker before. And so at the very least, the restriction on his phone privileges to contact family.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
Wait, he cut off his ankle monitor. One of the worst things you can do while out on bond. And at that point, it's no longer just about breaking rules, but about completely destroying the court's trust, which makes you seriously question whether any judge would even consider giving him another chance.
From my understanding, Judge, I thought community corrections still had it. I thought they had
he cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, you know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your mom gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls, as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something again.
This is a turning point. The judge isn't just frustrated. He's sending a clear message that actions have consequences. Ignoring court orders, violating bond conditions, and repeatedly contacting the victim shows a pattern of behavior, not a one-time mistake. Which raises a question of whether there was any realistic way he could have recovered his situation at that stage.
You're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kid say, mess around and find out. I guess that's not the quote, but yeah, that's close. But I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's burning by myself. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both of victims' new numbers and old numbers, so there should not be any more
calls coming through. All right. Thank you.
But of course, you know, she does
If
want.
she's worried about people knowing, she's going to end up either in jail or she's going to end up with a scram tether. Court calls the case, People versus Jocelyn is it Caruana?
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Caruana. Say your name for the record, please.
And Jocelyn Caruana, Your Honor.
Thank you.
Your Honor, we're here for pretrial. There's also a report that was sent by County Corrections.
Yes, a bond violation report.
Yes. I did have a chance to speak to Miss Karana about it. Actually, let me pull it up. There are a few things that are going on in that report. So the first are the late tests. Most of the tests are I think within like 20 minutes of the test period. I did emphasize to her that
On the 11th, the test was denied after she had been warned about things between the camera and her.
yes, if you look at the pictures, it looks like she's doing it out of her bag. I'm guessing she's doing it at work.
I was at work and I was kind of hiding it, and I
Kind of what?
I was hiding it from work when I was blowing. There are a couple instances where I have was told by Agent
Go ahead, what?
where I was told by Agent Mormon to take a picture if it was the time was off. I would blow in the morning and it would still continue to say that it wasn't being sent, like it had locked up. And then he told me just to send images whenever that time would show up. If I couldn't get it in that second timing. So then when I would blow at the second time, I would send him an image of it saying that it was blocked from 8:44. I was having kind of issues with it at the beginning.
And she did show me, she's been in constant contact with Agent Mormon. She showed me the text thread. I actually read basically the entire text thread where she showed that the SoberLink device has frozen, and it's locked her out until a certain time. He's recommended her turning it off or plugging it back in, or turning it off, turning it back on. And
that part I understand. It's the denied test where she had been warned that there can't be anything between her and the camera. And then I get a denied test.
Yeah, Your Honor, I think the explanation of her being at work and kind of trying to hide it from her coworkers, I recommended, stepping out into the bathroom or something. But of course, she does.
Well, if she's worried about people knowing, she's going to end up either in jail or she's going to end up with a scram tether. Because I'm not going to have these not blowing on time tests and then denied tests because she is trying to hide it.
Yeah, I mean the one test that the picture I received, it seems pretty clearly it's her, but of course it is obstructing. I would say a third of her face, half of her face.
That looks to me like it's me, but I do understand how it is obstructed.
We did talk about the possibility of a scram tether. I think, of course, we prefer that over any remand today. She hasn't had any positive tests. She's not
had any positive tests, but she doesn't blow on time, which I could consider a violation. And the camera is obstructed.
And I think she has made efforts to, stay in touch with Agent Mormon almost every time it's late. She's been sending Mr. Mormon a update or a text message, showing the issues with the device. I think she's doing her best to comply. I think obviously being told to come in person, this conversation is emphasizing the importance of no obstructions while the test is taken.
If I usually don't do this, she'll have a choice, given what I'm seeing here. She can either go on the scram or she can go to jail. Which does she want?
The scram.
I figure. I'll need a new order, an amended order. Defendant is to be placed on scram tether.
You may say with the 20 rounds, but since you're here, you know where they are, right? They're just
For failing to comply with SoberLink.
marks are at the front, but like it's behind the glass.
So you'll need to report over to community corrections placement on the Scram Gunner. We'll
Okay.
have the order over there by the time you get over there.
Okay.
And then what date did you want?
I think the 5th should be enough time, Your Honor.
I'll adjourn this to November 5th, 2025, 9 a.m.
Thank you.
Thank you.
Subscribe now and comment below. Was the judge's decision justified?